Right, welcome one and all. If you've been to our webinars before, you will know why we're looking at pictures of my pets and talking about Henk's disgusting gross lab. If you haven't, it's all a bit baffling, but what tends to happen is we have 10 minutes of just chatting with our mates before we start, and then we have kind of 45 minutes of law stuff, which is where Henk comes in very much. You won't have seen Henk before, I don't think we've done a webinar with Henk before. Here's our latest acquisition. Isn't today your first day in Chambers?
Yeah, no, today is my first day as a tenant.
Yeah, very exciting. Yep. Well done, Henk.
Thank you very much.
So it's congratulations all round. Henk was taken on in July, August time, wasn't it?
Yeah.
Now you get to be a tenant.
Exactly.
I always say to people, you're on probation for the first year. No one believes me. In fact, it's true. So we can't kick you out now. So Henk's our latest acquisition. Congratulations are also due to Dom Smith, who is also with us. Absolutely delighted. She's been named as a rising star in by the Legal 500. I actually think the Legal 500 this year has done a really good job, and not just because they've named Dom. I think it's a really good year for Legal 500 this year. I think they've been really accurate. So congratulations to Henk, congratulations to Dom. It's a great start to the day. It can only go downhill from here as we talk about the Montreal Convention. What will happen is that Henk will kick things off with a bit of the background stuff about exclusivity and carriage and who's covered by the Montreal Convention, jurisdiction, stuff of that nature. I'll then talk a little bit about what an accident is within the meaning of the convention and one or two other things, a few pleading points. Question from Sue Coles about how you plead the Athens Convention, Montreal Convention. Sorry, I'm getting confused between the two because they're really similar. And we did a webinar last week on it. And actually the answer to Sue is exactly the same this week as it was last week. So Sue, you can go now if you want. You've had the answer to your question. In terms of questions, you will see that there are buttons at the bottom of your screen, as always. There's a chat button. If you want to talk about cats, dogs and tortoises, use the chat button. If you want to ask us a question, it's easier for us if you use the Q&A button, because then we can see when it's a question that needs to be answered as we go along, as opposed to we're just chatting about other things. So please, if you've got a question, use the Q&A. If you want to stay anonymous when you ask questions, then please do that. No problem at all. The only problem with asking us questions anonymously is that if we don't get to them, or if you have to leave before we get to them, we can't answer them because we don't know who you are. Otherwise, we'll answer all your questions. As always, I certainly don't have anything else to do within the immediate future today, so I will stay on until I've answered all your questions. But if you do have to go and you are asking us a question, then tell us so, because otherwise we don't know and we won't be able to answer it. We are being recorded. We will be on our YouTube channel where all my followers are. Emma ruthlessly edits out the bits about cats and other stuff, but she does leave in all the questions. So we are being recorded today. So if you would prefer to remain anonymous, that's just fine. Yeah, I think, Henk, you're doing the first part, aren't you? So
yep, I'm doing the first half. All right.
Okay.
Let me just get up the questions so I can see when you guys ask questions. All right, so good morning, everyone. I suppose firstly, it's very nice to meet all of you, albeit virtually. And thank you very much, Sarah, for the introduction and obviously the cat photos. So on to the law. First things first, I think it's a good idea to keep in mind the legal framework of the Montreal Convention. And without even mentioning the B word that is Brexit, the legal framework is actually fairly confusing. I think it is useful to give a clear sense of the avenues through which the convention has effect in the UK. So I'll look first at the historic position and then briefly go on to the present position. So the Montreal Convention was obviously signed in '99. You guessed it, yep, it was signed in Montreal, and it replaced what was known as the Warsaw Convention. Now, the important point here is that the Montreal Convention has followed the general structure of the Warsaw Convention, and in many instances has adopted the wording there. So cases decided under the Warsaw Convention are certainly useful interpretive guides for the provisions in the Montreal Convention. So the present position. Unfortunately, the present position has been muddied slightly by the fact that the Montreal Convention applies in the UK through different routes, depending on whether the carrier is a community air carrier or a non-community air carrier. And a community air carrier is effectively an airline licensed within a member state. So in the UK, the Convention is the force of law by virtue of EU Regulation 889, which I'll refer to as the Montreal Regulation. And the Montreal Regulation applies to community air carriers. So far as non-community air carriers are concerned, the Convention applies by virtue of the Carriage by Air Act 1961, as amended by the Carriage by Air Act's implementation of the Montreal Convention 1999 Order 2002. Now, a point to note here is that both the Montreal Regulation and the Carriage by Air Acts modify the Convention so that the Convention applies to both domestic and international carriage. And that's obviously, for practical purposes, an extremely important point. So looking forward to the future position, Brexit has obviously thrown a massive spanner in the works. And it seems to me that, strictly speaking, if the UK were to leave the EU without a deal, the UK would revert to the pre-regulation position. So the Convention would remain in force by operation of the Carriage by Air Acts and the 2002 order. I note here that it does seem that there will be some edits to that by virtue of the air passenger, and this is quite a mouthful, the Air Passenger Rights and Air Travel Organisers Licensing Amendment EU Exit Regulations 2019. And that's not yet in force, but it may be worth having a quick look through that. So starting, I guess, with the substantive provisions, the starting point obviously is Article 1, which is the article governing the applicability of the Convention. In Article 1, subparagraph 1 of the Convention in its raw form reads as follows. So this Convention applies to all international carriage of persons, baggage or cargo performed by aircraft for reward. It applies equally to gratuitous carriage provided by aircraft performed by an air transport undertaking. So obviously, as just mentioned, claims brought under the Montreal Regulation and claims brought under the Carriage by Air Acts, the international requirement has effectively been excluded to some extent because the Convention will apply to both domestic and international carriage. So really then, I suppose for our purposes, the key clause in the applicability provision is the question of what constitutes carriage of persons, baggage or cargo. And I am slightly limited by time today, so I'll focus mainly on what constitutes carriage of persons. So the general scheme on applicability, I think, can be gleaned obviously by looking at the liability provisions in the Act. In Article 17, for example, is the provision dealing with liability for bodily injury, and it's targeted specifically at passengers as opposed to persons more generally. And really, this is the central point here. The liability provisions in the Convention, so Article 17, only apply to passengers. And the case law on this, on the question of who will and won't be deemed a passenger, is fairly developed. The general rule really set out here in the PowerPoint slide is that the Convention won't apply to air cabin staff and pilots. But as the House of Lords decision in Fellows and Clyde Helicopters shows, it does not follow that all persons who are on board a flight pursuant to a contract of employment will not be passengers. So the facts in Fellows briefly, essentially 3 police officers were tasked with conducting surveillance operations in helicopters provided by the respondents. Now the critical point here is that the police officers played no role in the operation of the aircraft, that being solely the role of the helicopter pilot. Now, unfortunately, there was a snowstorm and very tragically, the helicopter crashed into a block of flats and one of the police officers died as a result of his injuries. So one of the deceased police officer's widow subsequently brought a claim alleging common law negligence against the defendants. But the respondents argued in turn that this was clearly a scenario where the police officers were on board the aircraft as passengers, and that the claim fell within the exclusive jurisdiction of the Warsaw Convention, and presumably to make use of the various protections contained within that scheme. So Lord Mackay, giving the lead judgment, found that actually the police officer was a passenger, So although he was on board the aircraft pursuant to a contract of employment, the key fact was that he exerted no control whatsoever over the carriage, that being the sole responsibility of the pilot. Similarly, Lord Mackay found that the contract between the police force and the respondent was properly regarded as a contract of carriage. And so it followed from that the Warsaw Convention applied to the claim and had exclusive jurisdiction over it. So just briefly, the analysis deployed by the House of Lords and Fellows was actually supported by the Court of Justice more recently in the case of Wuche. Apologies for the German speakers amongst us. I am going to be butchering the pronunciation of some of these case names. So the case of Wuche Helicopter in Santa. And in Wuche, in short, the claimant was employed by a company operating ski pistes, and he was tasked with performing the specific task of avalanche blasting. And so the task was carried out from a helicopter, and during a flight, the claimant was seriously injured and brought a claim against the defendant, who was a community air carrier under Article 17. So on the question of whether the avalanche blaster, and my God, what a cool job title. The court found that the avalanche blaster was a passenger. So although he was on board pursuant to a contract of employment, he had no control over the operation of the airplane, and so he fell within the provisions of the convention. So the third case I'm going to discuss is actually a case on the Athens Convention, and that's Cairns and Northern Lighthouse. I note here that often judges will look at decisions made under the Athens Convention as an interpretive guide to provisions under the Montreal Convention. And at paragraph 50, Lord Drummond Young, who gave the lead judgment of the Outer House of the Court of Session, said as follows. The two conventions deal with broadly comparable subject matter, and in my opinion, some guidance as to the meaning of the expression in the Athens Convention can be found in that case, and that was the case he's referring to there as follows. So Cairns, the claimant was an employee of the defendant who travelled to the Isle of, an employee of Northern Lighthouse, who travelled to a lighthouse on the Isle of May in a vessel belonging to Calypso Marine, who were the second defendant. So the claimant was on board the ship pursuant to a contract of employment, but she again had no control over the carriage, and subsequently was deemed to be a passenger for the purposes of the Athens Convention. So moving now to what will and won't classify as air carriage, I think I can deal with this fairly quickly. So Disley and Levine, so that's a Court of Appeal authority, and there the court were tasked with considering whether a tandem paragliding flight fell within the meaning carriage of persons. And having regard to the probable intention of the convention, the Court of Appeal held that such a flight did not fall within the meaning of a carriage of persons, on the basis that a paraglider was not an aircraft, and the convention therefore did not apply. So a similarly obscure kind of factual scenario arose in the case of Laroche and Spirit of Adventure, and there the court held that the convention does not apply to hot air balloons. So if we can move to the next PowerPoint. So there is also case law, as I'm sure many of you are aware, on what constitutes international carriage. But I'm not going to discuss that today, mainly because the Montreal regulations and the Carriage by Air Act now apply to both international and domestic carriage. So really the importance of that case law for lawyers based in the UK is quite substantially lessened by that. So jurisdiction. The rules set out in the Montreal Convention provide the consumer with some degree of flexibility, and certainly more flexibility that would be allowed in the absence of that provision. So the jurisdictional rules set out in the provision, and you can see it in the PowerPoint here, they are exhaustive. And by way of summary, the claimant has a choice of whether to commence proceedings in the following locations. So firstly, where the carrier is ordinarily domiciled. Secondly, where the carrier has its principal place of business. Thirdly, where the carrier has an establishment by which the contract is made. Fourthly, the place of destination as disclosed by the contract. And fifthly, the place of the passenger's permanent residence, provided the carrier operates air carriage services from and has premises in that jurisdiction. So I think I should quickly address the possibility of a forum non-conveniens type of argument being brought against the defendant after the claimant has decided on which jurisdiction he or she wishes to bring their claim. To my knowledge, there isn't a case in this under the Montreal Convention, and I suspect the reason for that is that the issue was dealt with by the Court of Appeal under the Warsaw Convention in the case of Milor, SRL and British Airways. And in that case, the court held that a forum non-conveniens argument was not available to the defendant on the basis that uniformity was best achieved without recourse to forum non-conveniens arguments. So turning, I suppose, now to really one of the most important provisions in the Convention, and that's Article 29. So I think this provision, combined with the limitation provision contained at Article 35, has obviously been an extremely useful tool in the armoury of air carriers, in that it has created an extremely lethal pitfall for claimants. And indeed, the case law abounds with examples where otherwise valid claims have been cut down by the combined effect of Article 29 and Article 35. And I think Sarah will deal with Article 35 shortly. So the first case really on this that needs to be considered is the House of Lords decision in the case of Cedar and British Airways. And for those of you with an interest in history, I think the factual background is of some interest. So effectively in Soede, the claimants were en route to Heathrow from Kuala Lumpur via Kuwait at the beginning of August 1990. The aircraft landed in Kuwait after the Iraqi invasion had commenced. And whilst passengers were waiting in the transit lounge, the Iraqis actually invaded the airport. Some of the passengers were unfortunately detained and only released around 20 days later. What an absolute fiasco that must have been. Yeah, so the issue was that although the flight qualified as international carriage for the purpose of the convention, the claimants did not have recourse to the remedies under what was then the Warsaw Convention, because either there had been A, no accident within the meaning of the convention, or B, the injuries suffered did not qualify as bodily injury. And naturally, the claimants attempted to bypass those provisions and bring a claim at common law. So Lord Hope gave the majority judgment of the House of Lords in this case, and it was held that the common law could not be used in this manner. And I think rightly so, the judicial analysis actually started with the wording of the liability provisions. And at page 448 of the judgment, Lord Hope held, "I see no sign in the generality with which these provisions have been expressed of a recognition that there may be some actions of damages arising from the international carriage of persons by air, which are not subject to these rules." And pausing there, if we could quickly turn back to the wording at Article 29. The wording there is extremely general. So any action for damages, however founded. I mean, those are extremely general terms, and I think Lord Hope was clearly right in his analysis of that. So the second stage, really, of Lord Hope's analysis was the question of the damage that would be done to the uniform set of rules in the event that parties could seek damages under common law due to deficiencies in their claim under the convention. And at 453, Lord Hope held, and I quote, "The convention was not designed to provide remedies against the carrier to enable all the losses to be compensated. It was designed instead to define those situations in which compensation was to be available. So it sets out the limits of liability and the conditions under which claims to establish that liability, if disputed, were to be made. A balance was struck in the interest of certainty and uniformity. The domestic courts are not free to provide a remedy according to their own law, because to do this would be to undermine the convention. It would lead to the setting alongside the convention of an entirely different set of rules, which would distort the operation of the whole scheme. I see no escape from the conclusion that where the convention has not provided a remedy, no remedy is available." Now, although that decision was made under the Warsaw Convention, there have since been decisions in which the exclusivity principle has been cemented into the case law on the Montreal Convention. And I think the most important of those decisions is the Hook and British Airways and Stott and Thomas Cook claims. So I'm going to refer to this as Scott. These were joint claims, and this is really how it's referred to in the Supreme Court judgment. So the claimant in Stott sought damages for breach of UK disability regulations from the defendant airline after he was mistreated rather badly on a return flight from Zante to the UK. So the defendant airline sought to argue, obviously, that Article 29 acted so as to exclude such a claim, and that the claim must be brought under the Montreal Convention. And obviously the reason they did so was because the injuries suffered by the claimant in Stott were mental injuries, not bodily injuries, and the claim under the convention would fail as a result. So the claimant sought to argue that the subject matter of the claim was outside both the substantive and temporal scope of the regulation. The Montreal Convention, the claimant argued, was not concerned with giving access to air travel to disabled persons, and it was argued that it would be a mistake to use the convention to limit the rights and obligations that union legislation imposes in relation to such access. The defendant in turn sought to argue on the basis of Soede that the legal basis of Mr. Stott's claim for damages under domestic law was irrelevant. All that mattered on the defendant's analysis was that the claim for damages arose from the treatment of Mr. Stott in the course of his international carriage by air. And so Lord Tolson adopted the claimant's analysis of whether the claim for damages under disability regulations fell within the substantive or temporal scope of the convention. And as to the temporal scope, Lord Tolson held that the treatment suffered by the claimant clearly fell within the temporal scope of the convention insofar as it occurred during the course of carriage. Now, as to the substantive aspect, and this is certainly the more important aspect of Lord Tolson's judgment, Lord Tolson held that what matters is not the quality or nature of the cause of action, but the time and place of the accident or mishap. Lord Tolson considered that the convention was intended to deal comprehensively with the carrier's liability for whatever may physically happen to passengers for ill treatment in breach of equality law. With the carrier's liability for whatever may physically happen to a claimant during the course of carriage. And finally, Lord Tolson held that ultimately a claim for damages for ill treatment and breach of equality laws is a general class of damage that could not be regarded as being outside of the convention. And so looking at Cedar and Stott, clearly those are two extremely important cases, really affirming the exclusivity principle and preserving the scope of application for that principle. Now, the issue is that the jurisprudence on Article 29 has actually, in recent years, been watered down vis-à-vis claims brought under the denied boarding regulations. Now, the position as things currently stand is that, notwithstanding the decision in Cedar, a claimant can bring a claim for damages under the denied boarding regulations, despite the fact that compensation for delay is provided for under the Convention Article 19, and the apparent exclusivity of that regime under Article 29. Now, this development really started in the European courts, and so accordingly, I think it makes most sense to really analyse the European cases before going on to the case of Dawson and Thomson Airways. So the first really substantive decision on this is the case of International Air Transport Association and Department of Transport. So in this decision, IATA challenged the lawfulness of Article 6 of the denied boarding regulations. And it was submitted that because Article 6 provided for assistance and in some cases reimbursement in the event of a delayed flight, it cut across the right to compensation for delay under Article 19 of the Convention. And in doing so impinged on the exclusive jurisdiction of the Convention under Article 29. And I note, just for the sake of clarity, that at this stage, delays did not give rise to compensation for loss and damage, with that only really occurring after the decision in Sturgeon, which I'll come on to shortly. The court rejected the challenge. And the court held ultimately that the damage that was compensated for in Article 6 was outside of the substantive scope of the Convention. The position as articulated by the Court of Justice really was that Articles 19, 22 and 29 were concerned with claims for loss and damage of a specific and individual nature, and did not extend to the kind of loss and damage that is common to all passengers when the departure of a flight is delayed. And the CGU held that the generic loss and damage catered for by the denied boarding regulations could properly be made subject to a standardised form of redress. And this was on the Court of Justice's analysis fundamentally different to the compensation scheme set out in Article 19. So I'm wary of the time, so I will have to quickly go through these decisions and then go on to the issues arising from what constitutes the course of carriage. So the case of Sturgeon effectively expanded the remit of the denied boarding regulations insofar as the court held that actually a delay should qualify the claimant or passengers for compensation. And so the effect of Sturgeon really was that it rendered the denied boarding regulations arguably more inconsistent with the Montreal Convention than was previously the case. And this was duly challenged, of course, in the case of Nelson and Deutsche Lufthansa. Again, apologies if I've mispronounced that. I think that's correct anyway. So the argument in Nelson really was that if the denied boarding regulations conferred a right to compensation on passengers whose flights are delayed, as was held in the case of Sturgeon, it would conflict directly with the Montreal Convention, in that the Montreal Convention provided a right to compensation for delay under Article 19 and the exclusivity provision at Article 29. But the Court of Justice upheld the decision and held that the loss of time inherent in the delay to a flight constituted a general inconvenience within the meaning of the denied boarding regulations and could not be characterised as damage occasioned by delay within the meaning of Article 19 of the Montreal Convention. Now pausing there quickly again, clearly that finding is somewhat offensive to the wording at Article 29. And it seems to me that this line of case law has, in some respects, created the same patchwork of liability that the Convention was actually designed to prevent against. So finally, this issue arose for consideration in the case of Dawson and Thomson Airways by the English Court of Appeal. And the claim in Dawson arose out of a delay to a flight from Gatwick to the Dominican Republic. And the claimant sought to recover €600 under the denied boarding regulation. The complexity arose from the fact that Mr. Dawson began proceedings in 2012, which was just before the end of the 6-year limitation period under the Limitation Act. And the defendant obviously sought to argue the claim was governed really by Article 19 of the Montreal Convention, which had exclusive jurisdiction, and that the claim had been discharged by virtue of the 2-year limitation period under Article 35 expiring. So the court set out the European jurisprudence I just discussed, and Mr. Lord Justice Moore-Bick considered at paragraph 24 that he was bound to follow and apply the decision of the European Court in relation to the interaction between the denied boarding regulations and its relationship with the Montreal Convention. Lord Justice Moore-Bick considered that the question really was a question between the compatibility of 2 European instruments, and that the question needed to be answered as a result by reference to European jurisprudence pursuant to Section 3, subparagraph 1 of the European Communities Act 1972. But what about the decision in Soede? Clearly, there is inconsistency there. The decision in Soede affirmed the exclusivity principle in Article 29 and established an extremely wide scope for that exclusivity. Well, Lord Justice Moore-Bick didn't consider that he had departed from Soede, but rather that he had simply followed the decisions in the cases of IATA, Sturgeon, Nelson, and also Moore. So where does that leave us? Well, in the event of a long delay of more than 3 hours, claimants will now benefit from 2 separate schemes of liability: the scheme under Article 19 of the Montreal Convention and the scheme under Article 5 to 7 of the denied boarding regulations. So finally, moving now on to the course of carriage. So Article 17 obviously is the liability provision that deals with damage sustained in cases of death or bodily injury of a passenger. And there are, as you'll see from the PowerPoint slide, a number of important components here. And myself and Sarah will deal with these, I suppose, in turn. So the term on board the aircraft, I think, is unlikely to be problematic, except perhaps in an extremely unusual factual scenario. But the same cannot be said for what constitutes, quote, the operations of embarking and disembarking. Having looked at the case law on this issue, I think an extremely helpful decision for understanding this issue is the case of Phillips and Air New Zealand, which is a High Court authority on Article 17 of the Warsaw Convention, which is for all intents and purposes the same as Article 17 in the Montreal Convention. And I would refer all of you, if you wanted to have a really in-depth understanding of this provision, to paragraph 16 to 19 of that judgment. And Mr. Justice Morrison gives an extremely comprehensive analysis of really what constitutes embarkation. And I am conscious of the time here, so I'll quickly go through this. So in paragraph 17, Mr. Justice Morrison holds, there may be a number of operations of embarkation. The word operations is plural. This suggests that Article 17 cannot be confined in its application to the process of actually climbing over the threshold of the aircraft at the point of embarkation or walking up the steps to the aircraft if the aircraft is loaded from the ground. Now, the facts in Phillips were that the claimant suffered an injury while being carried on a wheelchair by an employee of the Air Terminal Services. The injury occurred in the terminal whilst the claimant was being transported to her gate. And Mr. Justice Morrison considered that she was in the process of embarkation. And in paragraph 18, he holds as follows. Standing back, it seems to me that going to the embarkation gate after the flight has been cooled is one of the several processes which passengers must perform in order to embark on their flight. The processes of embarkation will, I think, include the checking in, the passage through security and passport control, and the departure routine. That is, going to the gate to be cleared for embarkation and proceeding thereafter to embark. In the most general sense, these activities are required by the airline of its passengers. Now, there are a few other cases I've set out here, but I think I'm pressed for time here because I appreciate Sarah has also got a lot to go through. So Sarah, I mean, unless you have any objections, I think I should probably cede ground to you here.
Thank you. I mean, I'll never say no to somebody getting me to talk. Yeah, I mean, I think the process of embarkation, disembarkation throws up quite a few problems and issues in kind of real life situations. We can talk about some of those at the end, but suffice to say that it is a movable feast, and that the Warsaw Convention was really designed for those situations where people left a small building, left a shed basically, walked across the tarmac and walked upstairs to an aircraft. We're much more sophisticated than that now, and there's there are very difficult issues to be had about, you know, once you've been through passport control but you're shopping in duty free, are you then in one of the operations of embarking or disembarking? To my mind, probably not, because you're not doing something towards embarking or disembarking, you're just grabbing your last minute bottles of gin. So probably not, but there are sort of endless variations on that, which we can talk about a little bit later. But just for present purposes, going on to other issues which arise, because the Montreal Convention actually it's Article 17 that sets everything up, and lots of issues arise out of every single part of it, effectively. So what is an accident? And you would think that that wouldn't detain us for very long, but actually it's given rise to an enormous amount of case law, of, again, every conceivable variant. One of the problems that arose was that because the air carrier is liable for accidents occurring on board its flights, people started to push the definition of accident because there was no need for fault on the part of the air carrier. And Saxon Air France is an American case, which arose, I'm told, against a background of American students going off for summer break, coming back, having fights on airplanes. One of them would punch another one, and the victim of that punch would allege that that was an accident within the meaning of the Montreal Convention, and that would mean that they could claim damages from the air carrier, irrespective of the air carrier not having done anything wrong. And that was thought to be a bad thing, particularly when you got into situations where you had students with very high spirits punching each other for fun. And effectively, they were friends, and they were producing this, what I'm told is a glut of litigation in America arising out of that type of situation. Now, you have to be quite careful about that, because we're also told that there is a huge tsunami of fraudulent diarrhea-related claims, holiday sickness-related claims. I'm not entirely sure that that's right either. But in any event, that was an impression that the American courts got. And so we had this seminal case of Saxon Air France, which says, well, there's got to be an unusual or unexpected event, and that's from the point of view of the passenger. So this has got to be something out of the ordinary, and it's got to be something external to the passenger. So it can't be thrombosis, for example. And we got that from the DVT litigation. So that's got a very interesting tension between the requirement for an event external to the passenger and the English common law, which says that a passenger with an eggshell skull can still recover for damage done to them, and it's just your bad luck if you're a tortfeasor and you happen to get someone who's got an eggshell skull. So there's a tension there. If something normal and usual and expected happens on a flight and that causes an injury to the passenger, is it possible to say, well, that's not an event external to the passenger, that's the passenger's own vulnerability that has caused that? And I'm thinking particularly, and I think my instructing solicitors are watching this, I'm going to give them oral advice rather than written advice that they might expect later, that if you cause a bruise to someone who is unusually susceptible to bruising, does that then lead to, can that be said to be an accident within the meaning of the convention? And I suspect the answer to that is no. So there you are, you've had your answer. So Saxon, the DVT litigation established, we know there must be an unusual or unexpected event, it must be external to the passenger, and it cannot be part of the usual, normal and expected operation of the aircraft. Now, Barclay was an accident where someone tripped over their own shoelaces effectively. They tripped over a strip, a metal strip on the aircraft, and it was slightly raised. And the defence in that case was, well, that's just part of the usual, normal, expected operation of the aircraft. We get it a lot with litter. So at the end of particularly long flights, you will often find, or used to find, lots of litter on the floor. People who slip on that litter, that's an accident within any normal English meaning of the word, but it's not an accident within the convention, because it's been held time and time again that litter on the floor of an aircraft at the end of a flight is part of the usual, normal and expected operation of the aircraft. And so that's not an accident within the meaning of the convention. So the first question, once you've established that your accident has taken place within the course of embarkation, flight or disembarkation, is to ask yourself whether it's actually an accident. Some things that look as if they're accidents aren't, other things that look as if they aren't are. So it's always worth bearing in mind these questions. Ford and Malaysian Airlines, this really interesting case that Matt Chapman did, was a case of a lady who required medical treatment. She was given an injection on board the aircraft by a doctor, and it was held that that was not something unusual or unexpected. Now, in one sense, it is unusual or unexpected because stuff like that doesn't happen a lot on board aircraft. But the way the Court of Appeal and Ford and Malaysian Airlines system got around that was by saying, well, people administering injections happens all the time, and there's nothing air flighty about it. There's nothing connected with the operation of the aircraft about someone administering an injection which turned out to be negligently done. I think that's wrong for what it's worth, but it is binding. In Labardia and Alitalia, this is a Jack Harding case, conversely, somebody who I think slipped on airline steps, so one of those staircases down from an aircraft, that would normally not be held to be an accident within the meaning of the convention, because that happens quite a lot. That was held to be an accident in the meaning of the convention in Labardia because there was a failure to follow protocols. So something that happens outside a normal protocol of an airline or of an airport is going to be an accident, all other things being equal. GN and ZU is a European case. This is about coffee spillages. It doesn't answer the vexed question of whether or not people who spill coffee all over themselves are subject to accidents. Again, that would normally be an accident within the meaning of English law or English language. Sometimes it will be, sometimes it won't be. It depends whether or not you can establish why the spillage has occurred, and whether or not, therefore, it's within the normal operation of the aircraft. So if it's turbulence, it might well not be an accident within the meaning of the convention. Sean McCormack asked, would an intentional assault by cabin crew be an accident? So, for example, driving a food trolley into a passenger's leg. Yes, if you could show that it was an intentional assault, you're going to be able to show that it's something that is to do with the operation of the aircraft, because it's the cabin crew. It's unusual and unexpected from the point of view of the passenger. And as long as you've got an injury which isn't solely caused by the passenger's reaction to something of that nature, some sort of small-ish incident of that nature, should be okay.
Actually, Sean, there is a case on this. So I believe there's a House of Lords decision, Morris and KLM Royal Dutch Airlines, which actually involved a young girl who was decently assaulted by her neighbour, effectively, and the court held there that that was an accident for the purposes of the convention.
Thank you, Henk. You see, Henk has all the answers. An anonymous attendee asks, in your view, how would the court approach the reasonableness or proportionality of a specific disclosure application for the partial manifest from the flight in the context of an airline dispute, or put to proof that accident actually occurred as alleged or at all? That should be disclosable. It's disclosable as a matter of standard disclosure, so you shouldn't need to make an application for specific disclosure. The manifest should be disclosed in any event as part of both pre-action and standard disclosure. So if that's not being disclosed in a case, if you're acting for a claimant, you would be at liberty to make an application, and should make an application for pre-action disclosure in that regard. If you're acting for a defendant, you should be disclosing manifests. Because they will give information as to whether or not an incident has occurred, and as contemporaneous as it can be, documentation in relation to that incident. So the answer to that is yes, that's something that should be dealt with both in pre-action and standard disclosure. So as well as being an accident, there has to be either death or bodily injury. Let me just pause there and look and see if we've got any more questions about accident. In turbulence, Charlotte Wilk is asking, in terms of turbulence in the coffee scenario, would the decisions consider things like warnings from a pilot concerning impending turbulence, or is turbulence an implied continuous risk? Seems like a big grey area that no doubt extends beyond coffee type scenarios. Yeah, the answer to that is yeah, it is a grey area. And the GN and ZU European case doesn't really answer it. It says that it can be in certain circumstances, but doesn't have to be. Now, turbulence might be something that would be within the expected, wouldn't be unusual and unexpected. So turbulence in itself is not an accident, but turbulence that is part of a chain of causation might be part of the causes, and then one of the causes will be an accident. So turbulence might lead to something else that is unusual and unexpected, but is not in itself unusual and unexpected, I think. So moving then to the death or bodily injury points, I think Scott Rigby's here today, and he and I wrote an article not that long ago from which he will know, and anyone who's read it will know, that I've got views about this. The Montreal Convention, like the Warsaw Convention before it, only allows for damages in the case of death or bodily injury, and that gives rise to some slightly strange results in some cases. So turning then, sorry, I'm just looking at questions as well. So turning then to that case law, the case of Morris and KLM is the sexual assault case, and King and Bristow Helicopters, a fatal accident case, I think. Psychiatric injury alone is not enough. So if the claimant has only sustained, let's say PTSD, something of that nature, so you're talking about a sexual assault leading to depression or PTSD or something of that kind, then that is not enough. You cannot recover under the Montreal Convention for that. And because you can't recover under the Montreal Convention, and by operation of Article 29 Cedar, you can't recover at all. So the claimant in that case, a child sexually assaulted by a passenger sitting next to her, recovered nothing because it was only a psychiatric injury. And that is a throwback, I think, to the time when the Warsaw Convention, rather, was being brought into force. There was a thinking that you couldn't really prove psychiatric injury, that somehow psychiatric injury was somehow not really terribly serious. I mean, this was a time when people were getting shot for having PTSD from having suffered in world wars. So, you know, it's not exactly contemporaneous, but that's the kind of attitude that was brought to it. I think that we have moved on from that, but the convention has not kept pace with it. And it gives rise to some really odd results. So Glen and Korean Airlines is a case where people who saw an air crash would be able to recover as long as they could prove they weren't secondary, but they were primary victims. If you see an air crash, you can recover for it. If you're actually in one, you can't, unless you can show that you have suffered a bodily injury, and it's the bodily injury that has caused the psychiatric damage and that has flowed from it. Otherwise, you can't recover for your psychiatric damage. Jared Parker is asking, hi Jared, is asking, is unusually rapid depressurization of an aircraft causing long-term nasal problems or injury and accident? Well, you've got your bodily injury there because you've got your long-term nasal problems or whatever it may be. The answer to that is that if it's not unusual and unexpected, it's not going to be an accident. I've had one of these. In fact, I've had two of these, and they've gone either way. One of them settled, the other went to court and wasn't successful. So make of that what you will. It depends on the particular circumstances of the case and the surrounding context of it. But at first blush, I think it's probably not an accident because it's something that happens not infrequently. But in that case, you would have a bodily injury, of course. In our cases with the psychiatric injury, you don't come close to recovering because all you've got is PTSD that might have changed your life. Doesn't matter. It's got to be death or bodily injury in order to give rise to a claim under the Montreal Convention. The converse for that, and the reason why that is defensible in the case law, is that the carrier need not be at fault. So the convention, Warsaw and then Montreal, were both conventions that balanced claimant and defendant interests. So claimants missed out because they didn't get to recover for psychiatric injury. On the other hand, they had the very big boon that they need not prove fault on the part of the carrier. And that's why the carrier is liable for things done by other passengers as long as they are accidents. So you needn't prove fault if you act for a claimant in this type of case. There are no financial limits to the liability of passenger injury or death. And the air carrier cannot contest claims of compensation up to about 130,000 special drawing rights. And we heard last week that special drawing rights is this special sort of unit of currency that we use in conventions, international conventions, and it's about 1 to 11. So it's sort of roughly the same in pounds. Above that amount, so if the claim is for more than about £130,000, the air carrier can defend itself by proving it wasn't negligent or otherwise at fault. But it is for the carrier to prove that. So whilst I complain bitterly because there's this differential between physical bodily injury and psychiatric injury, so that I feel is unfair on claimants, there's an unfairness there for defendants as well, because air carriers are going to be liable with no need to prove fault. And that's not something that sits easily with an English common lawyer, where we're always looking for negligence, not under the convention. And not only that, but under the regulation, if a passenger is killed or injured, the carrier has to make an interim payment to cover immediate economic needs within 15 days of identification of the person entitled to compensation, not less than about £16,000. So not only does the air carrier not have a defence to a claim, it also has to make an advance payment, which it then can't get back. And that is about £16,000. And that's worth noting, a very underused provision, that. However, and it's a real roller coaster for carriers, this. Another corollary of this, and this is an important, the second half to the Article 29 issue that Henk was talking about earlier. Not only is the convention of exclusive application, if you don't bring your claim under the convention within 2 years, you don't bring a claim at all. The right to damages is extinguished if the action is not brought within a period of 2 years. And that is, we've been talking a lot about the Athens Convention and the Montreal Convention in the same breath. The case law crosses over in relation to the two conventions. And we saw that last week. We're seeing it again this week. Not with this, not with limitation. So in Athens, the limitation period can be extended by agreement, subject to a long stop, and it can be suspended, not extended, but suspended under the law of the forum. We saw that last week. In Montreal, you can't do that. You've got 2 years, non-extendable, non-suspendable. So if you don't bring your action within 2 years of the date, of the relevant date, the date on which the aircraft ought to have arrived or the carriage stopped, you've had it. And the only claim then is a claim in negligence against the claimant's solicitors. And Hall and Heart of England Balloons is quite a cautionary tale in that regard. The claimant's solicitors brought their claim against Heart of England Balloons, which was not an entity at the time of the accident. A particular individual was the person they ought to have sued. He was a director of Heart of England Balloons, but he wasn't the right defendant. They then sought permission to amend their pleadings because they'd slightly got it wrong in relation to what the legal entity was. After limitation, they weren't able to do so. You can't cure having sued the person under one of our civil procedure rules, because this is substantive law we're talking about. We're talking about substantive limitation periods. So it cannot be cured by amendment. And that is the single most important slide and the single most important thing I have to say today. And you've all heard me going on about this ad nauseum with Athens, but Montreal is even harsher if you act for claimants, even better if you act for defendants. And actually, if you act for defendants, all you do is keep stringing correspondence along until the claimant solicitors go outside the 2-year period. And once that happens, you're perfectly entitled to turn around and say, well, I'm sorry, you're outside limitation. There is nothing that the court can do about that. There's no kind of estoppel argument to be constructed. There's no kind of, well, you said and you didn't tell me and you strung me along type argument to be had. If you don't bring it within 2 years, you do not have a right of action. It has been extinguished and there's nothing the court can do about it. So limitation, really, really important in this regard. Again, I'm conscious that we're slightly going over, but you've seen this before in Athens, those who were here last week. Again, this convention is a complete answer. The measure of damages is not mentioned apart from the limitations that we've talked about. So the law of the forum in which the claim is brought is deployed in assessing the value of the claim. An interesting little wrinkle on that is a question that we were asked by Mark Fanning, I think, last week. Can a claimant recover for loss of enjoyment and diminution in value of a cruise? The answer to that, I said, was I'm not entirely sure, but I think they probably can. In relation to the flight, I don't think you can. So that is a distinction between the Athens and Montreal Conventions. Because you're talking about the flight itself, you're only contracting for a flight, and that wouldn't give rise to a claim for loss of enjoyment or diminution in value. As far as I know, there is no higher authority about that. Although I said that last time at Athens, and Jatinder Paul from Owen Mitchell reminded me that actually Owen Mitchell had tested that on Athens and had been successful in recovering loss of enjoyment and diminution in value, which just goes to say that I was right about it, really. So it's a moral victory for me. But in relation to Montreal, I don't think Jat's going to get on the chat now and go, yeah, we've done half a dozen of these and we've got loss of enjoyment back in all of them. But I don't think you can. So I'm willing to be proven wrong about that. Lastly, I think in relation to the claim form, this is Sue Cole's question, do you make reference to the convention on the brief details of claim? Yes, you should do that. It's exactly the same as the Athens Convention last week, but even worse, actually, if you're for a claimant. Wilding and Commissioner of Police, again, we heard about that last week in relation to pleading your cause of action, and you should do that both in the claim form and in the particulars of claim. In the context of the Athens Convention, we saw last week that in Adams and Thompson Holidays, that can be remedied. That I think actually is an outlier, as I said last week, and it's certainly not the way that the Montreal Convention has been interpreted in Hall and Heart of England, and actually not the way that it was interpreted in Cairns and Northern Lighthouse, which was an Athens case, but within which the defendant did not plead the Athens Convention, and they were bound by their pleadings. Now in Hall and Heart of England, again, you'll remember that was the case about substituting, because the claimant solicitors had sued the wrong legal entity for entirely understandable reasons, but it wasn't good enough. And actually, I've seen, and Matt Chapman, I know, we've both seen cases where we've pleaded claims against named airlines, and in both cases, actually, our instructing solicitors then amended what we had said in our particulars of claim and issued against a slightly different name of an airline. So where we'd said whoever it was PLC, our solicitors in their infinite wisdom then amended and pleaded against limited company or whatever it might be. And in each case, in relation to those, the claims were struck out because the claims had not been brought against the right legal entity, which actually is really scary when you take it together with the Soede and the limitation, Article 29 and Article 35 of the Convention. So Montreal is sort of a bit like Athens. You can rely on mostly the same case law, but actually even more stringent than the Athens Convention is in relation to limitation, in relation to how things have to be pleaded. That was all that I wanted to say, galloping through. We've overrun just a little bit, but not too badly given how many questions we had, I think. Any other questions? Let me just check. There we are. I've been thanked by my instructing solicitor for having provided the answer to her question in relation to bruising. I've told everyone now, everyone knows the answer to it, so the claimant can now withdraw their claim. So that's all to the good. That's alternative dispute resolution by webinar. Now, does anyone have any questions about anything, any cases that we want to talk about, or shall we sign off? I think we've had an hour, Henk, on the Montreal Convention. I think we've covered, and particularly you've covered, pretty much every case ever heard under it in the higher courts. So we've not done too badly, including the European courts. Yeah.
One more practical point, actually, I will just quickly address an interesting issue arose in Stott and Thomas Cook, which was the claim brought under the disability regulations. And the Treasury solicitor intervened. And the court actually found that had the claim been pleaded, so that the damage, the mental distress occurred prior to the flight, as seemed factually true, the claimant would have actually been able to bring the claim under the disability regulations, and the exclusivity jurisdiction, the exclusive jurisdiction of the convention wouldn't have applied. And so the point there, I think, is to really think about when does the cause of action materialize. And if it is prior to embarkation, but perhaps continues into the course of carriage, you may be able to plead a claim that isn't subject to the Montreal Convention. And so I suggest you really pay attention to that.
But in Stott, didn't they also say that you couldn't sort of say, well, your cause of action has kind of started prior to embarkation?
Yeah.
You can't get around the application of the convention by saying, well, they started doing the tortious thing earlier. Am I right?
So Lord Tolson's made a note. You shouldn't plead your case in an artificial way to get around the convention. But if it's factually true that actually your cause of action crystallized prior to the operations of embarkation, well, you should make sure to plead it on that basis, because then the Montreal Convention won't apply. Yeah. But no, you are right. Definitely avoid kind of artificially constructing a case to avoid the convention.
Yeah, I mean, my general rule on everything really is that if it looks like a duck, quacks like a duck, and waddles like a duck, it's a duck. The Montreal Convention sort of confounds that general rule, I think, because things that look like accidents aren't, and things that don't look like accidents can be. Yeah. So I think it's difficult. And secondly, now that anyone who's free to leave can leave, I can talk about my bodily injury hobby horse, which is that we're creeping closer to recognition that psychiatric injury is actually an injury. And there is some quite interesting scientific papers coming out of particularly America, but also some from our universities, to say that actually psychiatric injury is a reflection of changes in your brain. So if you can show on a scan that there's been an alteration in the structure of your brain, it may be that you can say, well, this incident has caused my brain to look different to how it looked before, and that is in itself a bodily injury. Yeah. But that is right on the cutting edge of what's possible under the convention, and it's certainly not consonant with the underlying teleological approach, the purposive approach of the convention, which is that it doesn't apply to psychiatric injury. But I think the time is if not right now, almost right for somebody to test that. And I personally don't see a reason why somebody should recover for a relatively minor physical injury and can't recover for a completely catastrophic
I agree.
injury. It just seems to me that that's not really how society wants to work at the moment.
Yeah, no, I completely agree with that. Medicine's evolved massively. I mean, our understanding of mental injuries has evolved massively since the convention was drafted.
Yeah, I think it has. And I think there was some sort of talk about it when the Montreal Convention came in, but not really adequately so. Right, well, now that I've got that off my chest, and thank you, Henk, for being patient with that. Next week, and I know that Emma's going to be very cross with me if I don't mention this, next week, Russell Wilcox and Katie Ayres will be speaking on Hans Husson and the Secretary of State for the Home Department. Actually, properly, I think, Crown against Secretary of State for the Home Department, ex parte Hans Husson, but we're not allowed to use Latin anymore. This is a case about Article 8, I think I'm right in saying, of the Convention on Human Rights, and it is all to do with deportation and immigration, which is very fashionably in the news at the moment, because Mr. Husson, as I understand it, was deported against his will, or rather the Secretary of State for the Home Department attempted to deport him against his will in circumstances in which he'd been given temporary leave to remain, but hadn't been given a work permit, even though he ought to have been given a work permit. So I think he was deported off to St. Helena or Ascension or wherever it is that Priti Patel is now deporting immigrants to, which apparently I'm told by someone who's been there is absolutely lovely. So Halls to St. Helena, if anyone is requiring holiday advice. So that's next week. Russell and Casey on human rights, I guess, is the headline of what it's about. And we will see you all there. Thank you for coming this morning. It's been an absolute pleasure.